Good afternoon. Good afternoon, class. This discussion is going to be an interactive discussion, so I will try to speak slowly, and I would like the participation of the class because, of course, this discussion is for my benefit and your benefit as well. And so I'd love you to participate. You can jump in at any point. You can share your own views on these issues as well. We're all colleagues, and you're going to have to deal with some of these issues at some point in your career. And so it would be nice if you can jump in and participate as we go along. Keep going. So the first objective that we're going to try to do is we're going to try to, because we're dealing with human rights, and whether you're litigating human rights or you're adjudicating human rights, you must be able to understand the concepts of implicit racial bias, implicit association, systemic racial discrimination, individual and direct discrimination. You must understand as well what the leading cases have said about racial discrimination, especially in the legal context. And you must be able to identify strategies for identifying and combating racial bias, even in your own thinking. So we'll go through all that today. So let's deal with implicit bias and systemic discrimination. And so this is what the Perception Institute says about implicit bias. It says thoughts and feelings are implicit if we're unaware of them or mistaken about their nature. We have a bias when, rather than being neutral, we have a preference for or aversion to a person or group of people. Thus, we use the term implicit bias to describe when we have attitudes towards people or associate stereotypes with them without our conscious knowledge. So implicit bias is essentially unconscious, subconscious. It's not something that you intentionally do. And so we go on to the next slide. And so this is implicit association. So implicit association is a connection that exists in a person's mind between a particular group and a particular attribute or tendency without that person's conscious knowledge. And for example, people may implicitly associate people of a certain race with violence or criminality. And so you look at Black men, for example, and studies show that Black men are often perceived subconsciously as more threatening, even as larger and more physically imposing than white men. And this implicit association may impact the disproportionate policing of Black men. And there is an article that was co-authored by Professor Nicholas Rule, and its title is Racial Bias in Judgment of Physical Size and Formidity, From Size to Threat. And that was a 2017 article. You can always take a look at it if you like. So this is what the Ontario Court of Appeal said, and you all probably went through this case already, Parks. It says racism, and in particular anti-Black racism, is part of our community's psyche. A significant segment of our community holds overtly racist views. A much larger segment subconsciously operates on the basis of negative racial stereotypes. Furthermore, our institutions, including the criminal justice system, reflect and perpetrate those negative stereotypes. These elements combine to infect our society as a whole with the evil of racism. Blacks are among the primary victim. And so that was a decision. Scroll back up to that screen, go back. Yeah, that was a decision in 1993, and you'll see we're going to come back to it when we deal with the MERS case. Okay, go ahead. So this is what the Ontario Human Rights Commission says is a definition for systemic discrimination. They say it could be described as patterns of behavior, policies or practices that are part of the structure of organizations and which create or perpetrate disadvantage for racialized persons. And so you'll see there's a few reports produced by the Ontario Human Rights Commission, and one of them is Collective Impact. And that 2018 report concludes that racial profiling is a systemic problem in policing, and found that a number of racialized over-policing practices, including the unjustified searches, meritless charges, and detaining of Black people without a legal basis, are the genesis of racial profiling. Then we have a Disparate Impact, which is a 2020 report. And that report found that Black people represent 36.7% of cases involving police strikes, and for the 1.1% of cases involving police grounding or use of force, despite representing only 8.8% of Toronto's population. So that report essentially tells you that the police react in a more violent manner when dealing with Black people if they're represented so high, so significantly in use of force incidents. Dr. Owusu Bempa, University of Toronto professor, did a study, and he found that 1 in 15 young Black men in Ontario experienced jail time at some point, compared to approximately 1 in 70 young white men. And when we speak about 1 in 15 young Black men, we're also speaking about brown men as well, South Asian males. So we come to 2021. We were just talking about parks. And so we come to Terrio. Terrio is a case involving an off-duty white Toronto police officer who was engaged with his brother in an encounter with a young Black man, Devontae Miller, and Devontae Miller ended up losing one of his eyes. And so the officer was convicted of assault and sentenced to imprisonment. And he applied for bail pending appeal. And this is what Justice Tulloch wrote in Terrio. He says, while often overlooked, Canada's long history of anti-Black racism has manifested in the contemporary phenomenon of over-policing and disproportionate incidents of violence during interactions with Black people and the police. Systemic and overt racism has long sustained unequal treatment before the law, leading to a crisis of confidence in the administration of justice in some communities. The current moment of reckoning with respect to systemic racism in Canada is long overdue. So this was a powerful statement by Justice Tulloch in the Terrio case, and the bail pending appeal was dismissed. So Michael Terrio had to report to jail and do some jail time. Now we got the case of Morris, and Morris is a case that deals with, it's almost like trying to see whether the Gladue principles can be applied to sentencing under Section 18 of the Criminal Code. And so in Morris, this was a 5-member bench of the Court of Appeal. And this is what they said in paragraph 1. It is beyond doubt that anti-Black racism, including both overt and systemic anti-Black racism, has been and continue to be a reality in Canadian society, and in particular the Greater Toronto area. The reality is reflected in many social institutions, most notably the criminal justice system. Anti-Black racism must be acknowledged, confronted, mitigated, and ultimately erased. And so I spoke to you about the Parks decision in 1993, and so we come back in 2021, we're still dealing with the same issue of anti-Black racism. So it's something for you to be cognizant of as future lawyers in your various practice areas. And so Morris set out a framework. And so the framework is in this PowerPoint presentation, which you all are going to have copies of, to consider when you're dealing with a Black offender in sentencing. So there's a whole new regime now where there are special reports that deals with the social, historical, and personal context of the person before a sentencing judge, not unlike the Glado reports that judges consider where there's an indigenous offender for sentencing. Next slide.
Selwyn, just before you move on, one of the themes of this course is, can it happen again? And we have recited many examples of racist policies, racist laws, racist interaction with police and all kinds of individuals. And then we come to present day and we say, can it happen again? If so, why is it happening again? In 1993, in the Parks decision, I think it was Justice Doherty who made that observation with respect to Black individuals. Now we're seeing in 2021, why in that almost 30 years, in your view, why things have not changed?
Well, it's all reflected, and you spoke of your discussion and affirmative action certainly provides a prelude or a prologue into this discussion, because certainly the institutions, if racism is embedded within society and we're not dealing with implicit bias, we're not dealing with implicit association, we're not dealing with how to disabuse yourself of your own biases when you're dealing with other people. We're not dealing with how can institutions be reformed, including our own justice system. Certainly, these situations will continue to emerge because there's no structural changes to the status quo. The status quo ante remains the same despite what is being written about and what's been said. And so, that's why the court said, hey, the moment of reckoning is now. We have to do something.
All right, continue, sir.
Any of the students wants to jump in? I mean, one of you must be ready to jump in and say something or challenge something. Let's hear from you. No one has anything to say at this point. All right, so we get to the lead decision from the Supreme Court of Canada. And this is an important decision that judges from lower courts, whether it's from the Court of Appeal of Nova Scotia or the Court of Appeal from British Columbia or the Superior Court or the Court of Queen's Bench in Nova Scotia, all judges have to pay attention to what the Supreme Court says because it's the highest court in our land and its decisions are binding on every other courts. So Lee says in 2019, we do not hesitate to find that we have arrived at a place where the research now shows disproportionate policing of racialized and low-income communities. This case was another example of a common and shared experience of racialized young men being frequently targeted, stopped, and subject to pointed and familiar questions. So this was a case in Toronto where the police simply walked into a neighborhood in a house in Alexandra Park without a warrant and began questioning a group of young Black and Chinese men who were socializing. And they made a find of a weapon, and it proceeded through the court. And certainly the case was thrown out on charter grounds, and that's what the Supreme Court had to say, that the police wouldn't operate in Forest Hill or Rosedale or Bridle Path in the same way they operate in Alexandra Park or Regent Park or Parkdale in Toronto. So this is what you must glean and gather from the cases that we discuss and the discussion or the dialogue between the professor and I. Implicit and overt racism are realities in Ontario. There's no question about that. Blacks, and I add brown people and Indigenous persons are among the most impacted by racial discrimination, but we're not alone. I mean, in 2021, you have Chinese people are now bearing the brunt of discrimination because of the COVID virus, and people, Donald Trump spoke about the China flu or the China virus and so on. So you have Chinese people now are experiencing a lot of racism, whether it's in Ontario or other parts of North America. Widespread and historical racism has given rise to systemic discrimination in Ontario and elsewhere, including police racial profiling and over-incarceration of racialized communities. And this has led to a crisis of confidence in our legal system. And you heard that repeated in the Theriault decision that I just cited. And obviously, we all have a role in acknowledging and combating racism. So let's deal with the human rights context.
Sullivan, just before you move on, I know you discussed the Theriault decision. Only yesterday or last night, there was a report that came out from the Waterloo Region Police regarding their investigation of that whole incident. And the finding was made that the father of Theriault, who's a senior police officer, was also present. That never came out before, but it also concluded that he did not have a role to play that evening. What are your thoughts about police investigating police with respect to these matters?
I mean, police investigating police is a problem. And it's a problem because of the mindset. When one goes into police college, they're trained that, look, you have to back up your partner, you have to be solid with your partner. And so it's drilled into the police officer's head from since they start training that you have to support your brothers and sisters. You can't go against your brothers and sisters. And you find that manifesting itself in these investigations. And that's why we have the OIPRD, the Office of the Independent Police Director, who is supposed to do these investigations as opposed to a police service looking into the misconduct allegations of another police officer from a different police service or a police officer from the same police service investigating a police officer for misconduct. I mean, the mindset are the same and they're reflected in these investigations and in these reports. I'm not one that supports police investigating police. I mean, there's an obvious bias.
All right, sir. Human rights.
Every person has the right to equal treatment with respect to services, goods, and facilities without discrimination because of race, ancestry, place of origin, color, ethnic origin, sexual orientation, gender identity, gender expression, age, or an intersection of these grounds. And certainly, the Human Rights Code prohibits racial profiling. So in terms of Black and brown people in Ontario, we have discrimination on various grounds. So we have walking while Black. So you can be walking in Regent Park and the police stop you. And they stop you on pretextually. They may say, well, you crossed on the red light. You didn't wait for the green light. And they take all your information and they send it to the gang suppression unit. And that's the case that I cited here, SA versus SA by Litigation Guardian AA versus Toronto Police Services Board. That's a case currently before the Human Rights Commission Tribunal, that deals with that issue. You have NM by his Litigation Guardian AA. That's another case before the Human Rights Tribunal, where NM was in Jane and Finch in his own high-rise complex when the police stopped this 15-year-old and decided they're going to investigate him for drug offenses and put a sound beating on him. So NM was 15 years old when this incident occurred. SA was 13 years old. So the kids aren't even safe in their own communities. They're not safe from the gang members, nor are they safe from the police. And that's quite an unfortunate reality. Driving while Black, you have Aiken versus Ottawa Police Services Board, a 2019 decision. And you have Maynard versus Toronto Police Services Board, a 2012 decision, and we'll speak about both decisions. Walking while Black, you have Phipps versus Toronto Police Services Board, and that's a case of a postal worker who was profiled by the police as he was delivering his mail. You have Noble and Peters versus Peel Law Association, and I'm the Peters, and that's discrimination in legal spaces. Working while Black, and then you have Sandu versus Regional Municipality of Peel. That's a senior police officer, an inspector with Peel Regional Police, who was discriminated on the basis of his South Asian origin. Shopping while Black, you have Graham versus Enterprise Rent-A-Car, and you have Nasaya versus Peel. So these are all decisions that found racial profiling, and so I put them there so that if any of you want to look into these cases, or if you have to work in this area, you have the reference to the case law. Slide. So in terms of litigating racial profiling cases, there are at least 3 forums that these cases could be litigated. So they could be litigated through the Human Rights Tribunal of Ontario. They could be litigated civilly along with other torts or contract breaches in the Superior Court, or one can file a complaint with the OIPRD. So, but we're focusing on human rights and the human rights process. So we'll deal with the benefits of the HRTO process. It is inexpensive. There are public resources available, so the Human Rights Legal Support Center can provide legal services to the applicants free of charge. It provides a semblance of justice to the victims, high profile, high visibility litigations. And there's one of them going on right now where there were 54 Black men, farm workers, who DNA were taken on the basis that a female was sexually assaulted by a Black man. And so these were 54 Black men. And interestingly enough, none of them fit the profile of the person who was ultimately arrested and convicted of the offense. And that matter has been heard before the Human Rights Tribunal. It started yesterday, and the Zoom link is online, and anyone could listen to it. So that'd be an interesting case, but it raises the point about high profile, high visibility litigation of racial profiling cases, and it brings the evidence to life in the public domain. It sets a precedence, and legal costs are not awarded to the applicant, nor are there cost consequences. So one doesn't have to mortgage their home or get a large loan from a bank because the cost isn't awarded against the applicant, regardless of whether they win or lose the case. No cost is awarded to them nor against them.
Selwyn, just before you move on, the 56 persons who were investigated, DNA samples were taken. Part of the discussion in this course, we talked about the temporary farm workers. These individuals were 56 temporary farm workers working on this farm. They were all gathered up and forced. Well, the police are arguing they were not forced. They voluntarily give the samples, but bull crap. And it was as if these individuals had no rights. And it would be interesting to see how that case plays out once it's concluded.
Yes, and you're right, sir, because usually the police have to go before a justice and persuade the justice to issue a DNA warrant. And in this case, there was no DNA warrant issued. The police simply created this sort of paperwork to indicate that these people were voluntarily given their DNA, but these were farm workers, seasonal farm workers who come from Jamaica, Trinidad, St. Lucia, and these countries. So they come here every year. Obviously, there's the fear that if they don't give their DNA, they're going to be deported or they're not going to be allowed to come back to work in Canada. So there's that sort of coercion that's there as well because of their citizenship status or their temporary status in Canada.
And I see Elisa has her hand up. She has a question or comment.
Yeah, this is maybe premature because I think you might be getting to it. And also it's just my lack of knowledge about the Human Rights Tribunal. But if someone goes up against, like, say, the police at the Human Rights Tribunal, what is the requirement for evidence, or like how often, I guess, do they go against police action? Because I feel like the police can kind of, like you said, they investigate themselves, but at the Human Rights Tribunal, they could kind of get evidence to support themselves more because they would have most of the evidence over, say, someone they stopped while walking or things like that. Okay,
that's a very good question. So, I mean, in the cases against the police, and I should tell you that police litigation before the Human Rights Tribunal is one of the largest areas of complaints because it's, as long as it's racial or it's gender-based or one of those grounds, it's a cheaper forum to litigate than the court. So people take their matters to the tribunal. But remember that these cases are mostly adjudicated if you're talking about racial grounds. Gender grounds, the evidence may be direct, but on racial bias grounds or racial profiling grounds, the evidence is circumstantial. So the police may, you'll remember that I discussed SA just now, the traffic stop. So the police may stop somebody and say, well, we're stopping you to investigate you for a broken tail light, or we're stopping you because you crossed on the red light. But essentially, the police are conducting a criminal investigation as opposed to a provincial offense or regulatory offense. And the fact that they lie to you, the fact that they provide you with an inconsistent explanation for the interaction could lead to an inference of racial profiling. So no direct evidence is necessary in human rights cases. You look at the circumstantial evidence, the evidence from the complainant and the evidence from the officers. But you can also look at social context evidence. So you look at wider evidence, such as the Human Rights Commission reports. You look at other reports, and that's why the lead decision from the Supreme Court of Canada is important. If you remember just now, I told you that that decision is going to be important for all of us, because that's what Lee says, that you could look at the social and situational context. You can also look at statistical evidence. So if Officer John Doe is stopping, let's say, Black men in Regent Park and issuing tickets and for crossing on the red light, you could ask for all his traffic stops or all his pedestrian stops within the last 6 months or the last year and analyze it, you know, to see what the race, gender, or the intersecting grounds are. And if Officer John Doe is stopping predominantly Black men and no one else, you know, all that are factors that can lead to an inference before the tribunal. So the rules of evidence at the tribunal is not as strict as it is in criminal court.
Perfect, thank you.
So this is a case that I was on, Mr. Aiken's case, and he was driving an expensive vehicle owned by his mother. He was carded by the police, and he filed a human rights application. And so the settlement in that case included extensive collection of data on traffic stops by Ottawa police. And Mr. Aiken was not satisfied with that. He wanted the expansion of the project to include pedestrian stops. And so in that case, we had like a hot tub. So we had experts provided by Ottawa Police Service and by Mr. Aiken. So we had two professors in that case who provided evidence. And ultimately the tribunal, which was chaired by Mark Hart, did not make that order, finding insufficient factual support and citing concerns as to the costs and practical difficulties of such an order. So he didn't make that order, but there are other cases in the pipeline where we're seeking to get the tribunal to order data collection on pedestrian stops. We have the Maynard case where Mr. Maynard was coming home from his office in a 1995 two-door black BMW. Toronto police were investigating a gun call in the Malvern Town Center involving a black male suspect driving a black sports car. And Officer Ryan Baker saw Mr. Maynard's vehicle and decided to follow it. And he did a high-risk takedown with his firearm drawn. And this was one of the largest award at the Human Rights Tribunal for racial profiling cases. So the tribunal ordered $40,000 and systemic remedies. Now, carding and racial profiling is not only a problem in policing. Lawyers are also subject to racial stereotyping and racial profiling. So the Peters that we're talking about is the Peters that's chatting with you right now. And so we went to the Brampton courthouse for a human rights matter. So there were lawyers from the Human Rights Commission. There were lawyers from Peel Regional Police. There were lawyers from Peel District School Board, and there was us representing the complainant KF. So there were 2 Black lawyers and a Black law student from University of Toronto. And one of the lawyers had dreadlocks, which is me. And the law student had dreadlocks as well. So that was an unusual scenario where you have the lawyer and the law students having dreadlocks. And the other lawyer is a Black lawyer as well. And I must tell you, the other Black lawyer is my first cousin. So Brian Noble in the Noble and Peters, Brian is my first cousin, and we were classmates in law school. So we were at the lawyer's launch waiting to be recalled. So we had argued a case, and the justice had sent us to the lawyer's launch while he pondered or write his decision, subject to recall. So the librarian saw all these people in the lawyer's launch, and most of them have never been to the lawyer's launch before, because most of the lawyers at the Peel launch are criminal lawyers. These were lawyers from Toronto who were dealing with a human rights matter. And the only reason they went to court is because when you're dealing with young people, you have to get a court order to release information under the Youth Criminal Justice Act. So we're there, and the librarian approached us. I was on the telephone chatting with my assistant in the office, and she demanded that I get off the phone because this is a launch for lawyers only. It's not for paralegals or members of the public. And she was pretty rude about it. She was pretty matter of fact about it. And so we had to share our identification. And as lawyers, because we have to flash it, we're almost like the police officers. So we all have our IDs like a badge. So we flash it because we have to show it every time we're going to courts or jails or so on. So we normally don't take it or we flash it. So she demanded that I take this ID out of my wallet so that she could physically inspect it, which I did. But she didn't approach any of the other lawyers. There were white lawyers, there were Chinese lawyers, there were South Asian lawyers in the launch. She didn't approach any of other lawyers to ask them for their identification. And so it really spoiled a good day for everyone. Everyone was relaxed and friendly and cordial in the lawyer's launch until after that incident happened. It added a degree of tension, embarrassment, humiliation to the dynamics in the launch. And so we filed a human rights tribunal application. The tribunal found that there was discrimination because the librarian lied. And that's what I was telling Alyssa when we were speaking about evidence in human rights cases. You know, she came up with this excuse that she didn't approach the other lawyers because she knew them. She knew all the other lawyers. She didn't know us. And when the other lawyers testified in the case, they all said they've never been to that launch before. I was the only lawyer who've been in that launch before that day. And so the tribunal found that lying was an indication of pretext. And lying is circumstantial evidence that goes to the finding of discrimination. It went to the divisional court, and the divisional court overturned the tribunal's decision. Justice Chapnick chaired the 3-member panel and wrote that decision. And then we went to the Court of Appeal with Justice Jurians writing this decision. And he said the question of whether a prohibited ground is a factor in the adverse treatment is a difficult one for the applicant. And this goes to your question again. This is what you need to know. Respondents are uniquely positioned to know why they refused an application for a job or ask a person for identification. In race cases especially, the outcome depends on the respondent's state of mind, which cannot be directly observed and must almost always be inferred from circumstantial evidence. The respondent's evidence is often essential to accurately determine what happened and what the reasons for the decision was. So there's your answer to the question. So circumstantial evidence is what it is. So Peters is now the leading case in human rights law in Canada, and it's been followed in hundreds of cases. And it was cited by the Supreme Court in Quebec versus Bombardier. And I appeared before the Supreme Court of Canada in Bombardier and was able to say why Peters should be followed by the Supreme Court in Bombardier. So it was quite nice to appear before the Supreme Court and argue this case and why it should be followed. So the conclusion on the Human Rights Tribunal's forum. The Human Rights Tribunal can be a powerful forum for justice in carding and racial profiling cases. It is expensive. The process can, however, be time-consuming. It is difficult to prove racial profiling and carding cases, as direct evidence is rare. Proof is usually by circumstantial evidence. However, once liability is established, there are a wide range of remedies, monetary and non-monetary, that can be awarded by the HRTO. And I thank you very much. And I'm looking forward to the discussion that follows.